A lease default letter is a document used when the other party in a rental agreement has breached a term of the agreement. The letter puts the receiving party on notice that the sender can cancel the lease within a certain amount of time. Lease default letters can be particularly important for parties planning to end leases in advance of their scheduled date. For example, tenants who leave a property before a lease ends because of a landlord's breach, but fail to send a lease termination letter, could remain liable for the rent owed until the end of the lease. State law limits the number of situations in which a lease default letter should be used. So your first question may be, when should a lease default letter be sent? If you're uncertain about whether to send a lease default letter, your first stop should be your lease agreement. The lease agreement, also known as a rental agreement, is signed by a tenant and landlord and contains the terms that will govern the lease. Along with setting out the rent, lease agreements identify all sorts of obligations for landlords and tenants. Tenants, for example, are typically expected to maintain a premises, while landlords are usually required to provide a property that is habitable. If either party commits a substantial breach of a material term of a lease agreement, it's technically grounds for breaking the lease, but in practice they are used much more frequently by tenants. This is because state law almost always requires landlords to go through eviction process, which has a separate set of rules, rather than sending a lease default letter. Now, tenants writing a lease default letter might be wondering how to write a lease default letter. There are relatively few requirements for lease default letters, but the key is identifying the term of the lease that has been breached. If you're a tenant, the lease agreement letter should be the first time a landlord hears about the breach you are alleging. As a practical matter and as a legal strategy, tenants should communicate with their landlord and ask for the problem to be resolved. If the landlord refuses, you should keep documentation of the refusal. Whether or not a breach is grounds for sending a default letter can be a complex question of state law. For example, in many states, the failure to provide heating is considered a breach of the landlord's duty to provide habitable premises. If you're a tenant and you think there is a duty in the lease agreement that the landlord isn't meeting, you may want to consult a tenants' rights organization in the area who can help you determine whether your situation calls for a lease default letter. We're eForms, the world's biggest database of legal documents. Click or tap on the link right here for more information about lease default letters, including a step-by-step guide on how to write one. And don't forget to subscribe for more videos that will help you manage landlord-tenant issues.